Now the decision of the 7 judges of appeal court to be final. Some of those calling for an end have done so in the belief that we can visit these issues another day and possibly after the general elections. But there are also self-serving calls instigated by anti-BBI crusaders. There are also those who believe very strongly that BBI is pursuing a just cause and that is being resisted in the same way the push for return to multipartyism and the struggle for a new constitution, among other landmark changes, have been resisted in the past, and that the promoters should proceed to the highest court in the land for a final word. As promoters of BBI bill, me and Junet Mohammed, we have weighted the options, suggestions, and reasons since last Friday. We have come to the conclusion that there is need for this matter to proceed to the Supreme Court. The initiative was supported by over 4 million Kenyans. Their overriding sentiment is that we must pursue this matter to the very end. We therefore wish to inform the country that as a secretariat, we shall be supporting the appeal of the Attorney General at the Supreme Court on BBI. We believe that the Supreme Court has a wider and more encompassing mandate when dealing with the matters of great national interest than the High Court or the Court of Appeal. Section 3 of the Supreme Court Act says that the objective of the Supreme Court is, among other obligations, develop rich jurisprudence that respects Kenya's history and tradition and facilitate its socio, economic, and political growth, enables important constitutional and other legal framework, including matters relating to the transition from the former to the present constitutional dispensation, to be determined by having due regard to the circumstances, history, culture of the people of Kenya. This very wide mandate in interpretation of our Constitution is given to the Supreme Court judges because in times of national crisis like we are, and which we are leading to now, they can innovate and steer the country towards unity and growth. We believe that the 2 lower courts failed to appreciate the delicate balance needed in resolving an issue like the one before us. And only the Supreme Court judges have both the vocation and the mandate to do so. We, however, take note that the Court of Appeal judgment made some significant positive pronouncement on BBI, which represents important progress from the High Court ruling before. This includes, number 1, the affirmation of legality of BBI Task Force and BBI Steering Committee. Number 2, affirmation that the President has powers to establish ad hoc committee and bodies. That was affirmed in the ruling. Number 3, affirmation that came out from the Court of Appeal is that the promoters of BBI are Junet Mohammed and Dennis Waweru under Article 257 of the Constitution. They also affirmed that the role of IEBC under the Article 257(4) is to verify an initiative, and it was supported by 1 million registered voters. That was affirmed, and not to verify of the authenticity of the signatures. Number 5, affirmation is that IEBC has mechanism to verify an initiative by using its register of voters and biometric as it is and as it did in BBI bill. The other affirmation that we got from the ruling is that the county assemblies and parliament cannot alter, vary, or change the content of a constitutional amendment bill during their consideration. Number 7 affirmation that we got from the ruling is that the referendum question are to be contained in one bill as opposed to multiple questions. And so we are proceeding, and I want now to leave my colleague, my co-chair, to read the rest of the statement that we are issuing today. Karibu sana, Mwesh.
Thank you, Chair. Now, I want to proceed from where he stopped, that we want to keep pushing because we are determined to ensure that some of the very novel proposals in the BBI are not lost. And if they have to be lost, it must be known that we made our best efforts to secure them. There is the real possibility of a national crisis if some of the BBI provisions don't become law. For instance, BBI is intent on finally settling the gender question in Parliament. As we all know, Justice David Maraga, the immediate former Chief Justice, issued an advisory that Parliament is unconstitutionally constituted and will not be properly so unless the gender questions are implemented. There is also no other likely way to resolve this matter. All previous attempts have failed. It is impossible to constitute a new parliament without the solution to the gender equation. This needs urgent attention, and the solution of BBI is the only viable solution in our view. We need the highest court in the land to pronounce itself on this matter. This country needs to deal ruthlessly with the scourge of corruption. The public agrees that corruption is a threat to the existence and well-being of Kenya. The BBI has recommended several innovative measures to deal with the menace, including speedy prosecution and conclusion of corruption cases, stiffer penalties, aggressive recovery of stolen public resources. We believe strongly that we also believe strongly that more resources need to be devolved to the counties, all the way to the wards. We want the Supreme Court to take a stand on these matters. There is also the issue of inequality in Kenya, which traces its origins to the social and economic policies of the colonial era and the immediate post-independence period. The policies we have pursued over the last 50+ years have made Kenya many countries in one. It's a fact that while a section of Kenyans have done extremely well, others have grown extremely poor over the same period. It's a fact that the country has not generated sufficient jobs, and people are getting very frustrated at the lack of sufficient opportunities and absence of social protection to the poor and vulnerable. The BBI has some viable proposals on how to create an economy that works for every Kenyan, how to address taxation, how to strengthen agriculture, livestock, and industrial sectors in rural areas to create jobs and eradicate poverty. We want the Supreme Court to pronounce itself on this matter. This country has been consumed by election-related violence since the return of multi-party politics in the 1990s. The period to and after elections have become civil wars in which the country loses property and innocent lives because of contest for power. It is the intention of BBI to avert the election crisis as that witnessed in previous elections by reforming the governance structure of the country. Again, there are no alternatives, and we're about to conduct a general election in less than a year. We want to hear from the Supreme Court on this matter. There are many contradictions in both the High Court and the Court of Appeal rulings that will create confusion and legal chaos if not settled with finality. The Attorney General will detail this in his appeal. Kenyans deserve clarity on the basic structure doctrine. We feel that as it is, the judiciary has amended the Constitution of Kenya and written processes into it that Kenyans did not discuss or vote on it. It has also literally, unilaterally, and mischievously deleted Chapter 16, which allows an amendment to this Constitution by a popular initiative. It is said that every great achievement was once considered impossible. This is very true of this country. Everything we enjoy today is a product of a bitter and painful struggles. Multi-party politics, the Constitution of 2010, devolution, all these are products of painful struggles. We are determined to soldier on. If the lessons of the past are to be our guide, the BBI too will come to be realized if we fight hard enough, and we are determined to fight hard enough. Tuwe na imani. By Honorable Junet Mohammed and Honorable Dennis Waweru, co-chairs of the BBI and the promoters of the BBI bill. That's the end of our statement. Unless you have any question.
So what we are saying is we are supporting the AG at the Supreme Court, me and Junet, on behalf of more than 3 million Kenyans, 4 million Kenyans who signed for BBI bill, because we cannot allow the courts to take away the constitutional right of Kenyans to amend the 2010 Constitution. So we are going to pursue it all the way to the Supreme Court, and we are going to support the Attorney General in that endeavor, because we believe the judiciary should not take away the right of Kenyans to amend the Constitution.
All right, so there you have it. Breaking news on your screen right now. Team BBI, the Secretariat team led by the